I don't want this to sound like a small issue, because I think it's actually a very significant issue. So I actually disagree that the electoral exceptionalism idea is not central to the McConnell decision, which upheld the McCain-Feingold law, particularly the bans on corporate and union spending on electioneering. And maybe this will help sharpen up a little bit of what's at stake and what's not at stake. The justification for the ban on corporate and union electioneering is that this spending of money at these levels has the capacity and had the reality of corrupting the judgment of public officials, of distorting their judgment and the reasons for their judgment about issues of public policy and public moment. Now, the reality is that the court can apply the formal structure of existing doctrine, which I gather is what you think they did in a case like McConnell, and say, well, there has to be a compelling interest, but there is a compelling interest here to justify these restrictions because of corruption, or the concern of corruption. But the truth is, we don't have and will never have the kind of evidence to justify that judgment, because, as we all know, proving empirically the relationship between very large contributions of money, either in the form of contributions or spending, including from corporations and unions, that changes the judgment of public officials from what they otherwise would have decided was desirable policy, is an incredibly elusive issue to figure out as an empirical matter. And if the Supreme Court were rigorously applying the general conception of the First Amendment to this, it would have to say that there's just not sufficient evidence to justify the claim by Congress that this kind of spending was corrupting of the judgment of public officials. But in McConnell, the court accepted that judgment nonetheless. And why? I think the reasons, although of course they don't use the language of electoral exceptionalism, which I wouldn't expect, but I think the reasons reflect the kinds of ideas that I'm trying to capture through that label. Because I think, at least in McConnell, the court was prepared to accept a political judgment that the massive spending of this kind of money, particularly by these actors with the sources of wealth they had available, could be judged to be corrupting enough that it compromised the purposes of democratic elections, which is to empower a set of legitimate officials to exercise their best judgments about appropriate public policy. And so I actually do think that these kinds of ideas are central to understanding McConnell, and that you can't say that McConnell is simply an application of the general off-the-rack conception, and we don't need to think about elections as a distinct sphere that raise distinct sets of issues and justifications for regulation that would otherwise not be accepted in the general sphere of public debate. Number one. Number two, this vision is not the vision that an election is like a trial. I know that Justice Stevens has kind of suggested something like that, and I don't for a minute think that's an appropriate way to think about the hurly-burly and the contestation of elections, and this is not a kind of, highly structured affair that it's okay for government to say, you speak now, then you speak. But the point of the trial example, as you know, is simply to offer one of many, many, many illustrations of different kinds of institutional settings in which doctrine has long recognized that there are appropriate justifications tied to the very reason we have these institutions for understanding the application of the First Amendment in particular ways in these settings. So, of course, I reject the framing that we're talking about lesser protection or greater protection, because that already adopts the off-the-rack kind of conception as the right baseline. I think the question is, what are the appropriate regulations and the impermissible regulations of speech given the particular social institution and the roles and the purposes and the functions that we want it to play in the larger sort of social and political order. So, I don't know, do you say that, the court has recognized lesser First Amendment rights for corporations and unions because they can't contribute money to candidates in elections, I would say the courts recognized an appropriate understanding of the First Amendment in the context of elections, because we don't want corrupt office holders. And that's sort of a matter of language, but I do want to kind of reject that framing. You're absolutely right, and of course, you know I agree with you, that there's always a tremendous risk when government actors are regulating the political sphere, that they'll regulate it for self-interested, partisanly oriented reasons. And we always have to be attentive to that concern. But when people say that, I think they often leave out the fact that there's also a serious risk that the failure to do anything in these areas, it could be equally self-serving. In fact, if you're going to start with a presumption, it ought to be that the people who are elected under an existing set of rules are the last people who are motivated to want to change those rules, because they hate the uncertainty, they know the game under the rules as they've been designed. And so, of course, you have to be suspicious when they regulate the electoral sphere, but you can be suspicious when they don't regulate as well. So it's just a very, very knotty problem from the start. And I don't think the problem can be solved by a presumption that there's not an incumbent self-entrenching basis for the refusal to enact campaign finance laws of one sort or another. Now, you know, elections are much more structured than I think many people remember. So, for example, we have laws that require members of Congress to be elected from single-member districts rather than at large. Why? Because we had at-large elections at periods in the past, and a statewide majority of 52% could control the entire congressional delegation from a large state. And that was thought to be an unfair way or an unrepresentative way for elections to be organized. So we made a choice. Since 1842, the choice has been in place that we'll have a better system of democracy, a better system of elections, a more legitimate system of government, a fairer system of representation if we use single-member districts. So a conception of what democracy is for underlies that structural choice. We have mandatory primary elections for similar kinds of reasons. So I think the idea that the electoral sphere is going to be structured, I don't know, without regard to some set of judgments about what creates a healthier, more vibrant, more representative, more legitimate democratic experience seems to me that has to be wrong. And the question is how the First Amendment then should be integrated into that larger framework. As I say, at least with respect to this issue of corruption, corrupting the judgment of office holders, it seems to me that it's very much at the core of the reasons we have elections in the first place, that regulations which legitimately serve the purpose of reducing that risk ought to be understood to be consistent with the First Amendment and not fundamentally, you know, antagonistic to the First Amendment.
I'll take a minute. We'll leave time for questions. Just two comments. First, Rich still hasn't told us, and this is important, what standards would apply in a world of electoral exceptionalism, and how we would think about other kinds of regulations of the electoral process that would now be thought to be unconstitutional, that might then be constitutional, and what might they be if they're put together by a Republican House, Senate, and White House? And are we prepared to say that the court should give them deference? The second point is, Rick, I think is very wrong about the standards applied in the campaign finance case. They are not the highest standards of First Amendment review. That's just not true. These are not viewpoint-based rules. These are not even content-based rules, except in the most vague background sense. These are basically content-neutral regulations of speech. And so the court's not applying clear and present danger here. It's not applying the kind of standard it would in the most dangerous forms of regulation. Essentially what it's doing is balancing, in which when the court thinks that the impact on speech is relatively modest, as it did in the contribution situation, it upheld the regulations on the theory that, well, these are not terribly obstructive of free speech, and therefore a legitimate substantial
Can I
justification
just
sufficient.
explain to you, because I've always wondered about this. How is singling out corporations for different rules not a form of viewpoint discrimination in the ordinary First Amendment sense?
It's a speaker-based rule, and speaker-based rules, despite what Kennedy said in his opinion, are not presumptively unconstitutional. They exist all over the place under the First Amendment. So viewpoint is different from identity of the speaker, unless the identity of the speaker is defined by their adherence to a particular viewpoint, like communists. Right? A law about communists is both speaker and viewpoint. But corporations are not a viewpoint. And for an example of this is the court unanimously upheld a law that gave that exempted from the rule prohibiting lobbying by nonprofits veterans organizations. And the court unanimously said this is a speaker-based rule. It's not a viewpoint-based rule. It's not a content-based rule. There's a reasonable justification for it. It's okay. And rules regulating corporations for that reason should not be unconstitutional. That part of Kennedy's opinion is nonsense, frankly. So the right way, to my view, to understand the issue in these cases is that these are content-neutral regulations of speech, and the first question is how severely do they impair the ability of individuals or organizations to engage in effective free speech, and second, how strong is the government justification? And I think that's the right way to understand what's going on here. This is an off-the-rack rule, but it's not the rule that's being taken off the rack is not the one that says you have to have clear and present danger or anything along those lines at all. It's a balancing test for content-neutral rules. So we should open up for questions.
I was going to lead off with one quick question, and then I was going to open it up to the floor. And this is kind of bringing it to a more concrete level for our own work. As you both know very well, this term the Supreme Court considered McComish versus Bennett, which might be thought to raise the question of electoral exceptionalism in a slightly different way, in that, McComish is a case in which the government is not trying to level down to restrict some speakers so that weaker speakers can be heard more. Instead, McComish is a public financing case, a subsidy case, in which the government may be thought to be taking a leveling up role, to be enhancing speech within the electoral sphere rather than restricting it. And, how does the concept of electoral exceptionalism apply, if at all, there? And does it cause us to suspend our normal skepticism of government interference, whether restrictive or enhancing, in the electoral sphere?
Well, I think my view is that even under the general conception of the First Amendment, I have a hard time understanding what the First Amendment problem is in the context of the Arizona public financing case. As Monica said, the case involves a grant of an initial amount of money to a publicly financed candidate, which can be increased. It can be doubled, and then one more increment of the same amount can be given based on how much money a privately financed candidate spends. And the Supreme Court seems likely, from the oral argument, to strike this down as a violation of the First Amendment on the theory that granting more money to the publicly financed candidate in relationship to how much money the privately financed candidate spends is a penalty on the First Amendment rights of the privately financed candidate. I just have trouble understanding, in general First Amendment terms here, how this can be understood to be a penalty. For example, the government could just grant the publicly financed candidate the total amount of money that he or she gets under this trigger system at the outset, and there would clearly be no First Amendment problem. I think the government could give that initial grant at that very high level out and say, but we'll take back money from you if your opponent doesn't spend more than a certain amount, and I can't see how that would be unconstitutional. So, I'm going to be wrong about this. I predict that our mutual friend and former colleague of Jeff, Justice Kagan, may be writing the dissent in that case because she was a First Amendment scholar who apparently didn't learn well enough from Jeff at the University of Chicago and was very active on the bench in criticizing where the court seems to be going on this. But to me, just in general First Amendment terms, I have a hard time understanding how this can be conceptualized, how more subsidy to a publicly financed candidate can be conceptualized as a penalty on the First Amendment rights of the private candidate.
Okay, so again, without suggesting that I disagree with Rick on the result here. Again, I want to keep clear that I'm trying to talk about particular arguments, not about the results. On the question of how is it a penalty, right? Why does it raise a First Amendment question? That's actually pretty simple. Suppose, for example, the state enacts a law that says if a newspaper endorses a candidate, it has to give free space to the opponent, and we'll pay for it. So there's no financial cost to the newspaper. Okay, I suspect the court would strike that down in a totally separate context, because it would say that essentially your time, effort, energy, and resources that you devote to speech are diluted by the government when they immediately enable your opponent to have a benefit because you've spoken. So you're much less likely to speak. If you know that if you decide to give $100 to your favorite candidate, and the government will automatically therefore match it by giving $100 to your opponent, you're going to think twice about giving the first $100. And the question is then that the government is deterring you from exercising your right to free speech. So I don't think it's accurate to say there's not a serious First Amendment issue here. There is. The government's not supposed to be taking action that has the direct effect of chilling the exercise of free speech rights. And the argument is that's what's happening here.
I still don't understand it, because the empirical fact that you might do less of the conduct, you might spend less to campaign, that can't be something that the First Amendment considers a violation, that in itself. I mean, public financing could deter private candidates from running for office. Disclosure rules could have a chilling effect in this empirical sense. So it seems to me you can't possibly be the case that this is to be conceived of as a First Amendment penalty merely because it might lead a privately financed candidate to spend less money. That can't be. The argument has to be conceptually or in theory or in principle that it's a penalty for the government to provide more money to the publicly financed candidate, and that I just can't understand conceptually.